Hear ye, hear ye, hear ye. The Colorado Court of Appeals is now in session. Please be seated.
Good afternoon. Welcome, everyone. This is Division 5 of the Colorado Court of Appeals, and we have one case on our 1:30 docket. I see the counsel are present at council table. I am Diana Terry, and I'm the head of the division. I would like to introduce Justice Martinez, seated to my right, and Judge Marquez, seated to my left. We're happy to have you here today. I would ask you please to turn off any device that you have that might receive a text or an email during the course of our arguments, because it could interfere with our recording system. We are live streaming on the web right now, and you have the opportunity to go back and look at these arguments later on if you like to do that. You should have received written instructions about our oral arguments. If there are any questions about those procedures, now's the time to ask them. You need to keep track of your time. So, hearing no questions, you may proceed, counsel.
Good afternoon, Justices. I'm Mike Mitchell. I'm the attorney for Bryce Ranum, the appellant in this matter. This case revolves around an accident that happened on March 1st, about 2016, about a little before 8 o'clock at night. The circumstances of that accident are kind of important. Mr. Ranum was traveling northbound on Jordan Road in Parker, Colorado. He was traveling at about 70 miles an hour at the time of this accident. The speed limit in the area where the accident took place was 40 miles an hour. The evidence was that Mrs. Baghdadi, the defendant, turned left in front of Mr. Ranum, and as a result, Mr. Ranum's vehicle ran into her vehicle. The evidence was that she made this left-hand turn in front of Mr. Ranum between 1 and 2 seconds prior to him arriving at the intersection. The trial court gave an assumption of risk instruction in this case, which basically held that Mr. Ranum knew of a known danger and consented to that danger. We don't feel that Mr. Ranum knew that anybody was going to turn left in front of him as he was traveling down the road. Yes, he was speeding. Yes, that was wrong. But at the same time, Mrs. Baghdadi made the conscious decision to turn left, and that turning left caused the accident. We feel that the assumption of risk instruction given by the trial court was in error.
Before you talk more about the assumption of risk instruction, I would be interested in your response to the argument that was made by the defendant, which was basically that the jury never reached that issue. The jury filled out special verdict form A, and the jury found that the defendant was not negligent, and therefore did not proceed beyond that to consider the other issues.
I don't know what weight the jury gave to the assumption of risk.
Well, first of all, you do agree that that's the correct as far as what happened below, that the jury filled out A.
Correct.
And did not reach the other issues. So now you're just going to talk about whether it had an evidentiary effect on the issue of whether the plaintiff was negligent. Is that correct?
I don't believe so. And the reason I state that, Judge, is the jury looks at all the evidence in coming to a decision, at least they're supposed to. What weight they gave to the assumption of risk, I don't know. Nobody knows. The fact that the jury came back and said the defendant was not negligent, is that because the jury found that the plaintiff, Mr. Ranum, had assumed the risk of this accident happening? of somebody turning left in front of him. Did the jury find that because he was speeding down the road that Mrs. Baghdadi could not have been negligent? I don't know. But to find under the...
Isn't an assumption of risk, and I certainly understand what you're saying from an evidentiary standpoint, but from a legal standpoint, isn't an assumption of risk the assumption of risk that someone else will be negligent? And if someone else is not negligent, does it apply?
I'm not sure exactly what you're asking. Assumption of risk is an accident happened. Whose fault was it? Was it the defendant's fault? Was it the plaintiff's fault? Was it a combination of the two? One of the factors to be considered, obviously, under the assumption of risk is, did somebody assume or know of a known risk and consent to that risk?
Was a jury, what did the assumption of the risk instructions say? Did it say anything at all about defendant?
About the defendant? It was just the standard stock assumption of risk instruction, negligence with assumption of risk.
Did anybody argue that it applied to defendant?
During closing arguments?
Anytime.
At any time? I don't recall anybody arguing, or myself arguing, the fact that the defendant assumed the risk. I think the only arguments that were made were by Mrs. Baghdadi and her counsel that Mr. Ranum assumed the risk by his driving behavior. So I don't remember anybody arguing that it was that Ms. Baghdadi assumed the risk. The evidence in this case was that Ms. Baghdadi turned left in front of oncoming traffic, and that as a result of that, she was the proximate cause of the accident. That was from Officer Faulkner, the investigating officer, who testified as an expert witness in this case. The two eyewitnesses to the accident, Cindy Kindle and Luke Kindle, both testified that Mrs. Baghdadi should not have made the left-hand turn. Luke Kindle testified that there was nothing that Mr. Ranum could have done at that point in time to avoid the accident. The only evidence from the defense was their expert said, well, you know, if Mr. Ranum would have been traveling at 40 miles an hour instead of 70, there would not have been an accident.
Counsel, I'm sure you're not asking us to reweigh the evidence.
No, I'm not asking.
So the legal point that you're getting to
The
is...
legal point here is when looking at a jury verdict, you're supposed to take all the evidence, and you're supposed to view it in light of the successful party, here Mrs. Baghdadi. But you're to look at it, is there competent evidence in the record which can logically support the verdict of the jury? So looking at all the evidence, everybody saying that it was Mrs. Baghdadi made an ill-advised left-hand turn. Defense witness says, but if he would have been going the speed limit, there wouldn't have been an accident. Is that competent evidence?
It does sound like you're asking us to reweigh.
Well, I'm not, that's kind of rhetorical. The fact of the matter is that you're driving, as a practical matter, you have to make a decision at the moment on whether you're going to turn left in front of oncoming traffic or not. It's not, what if this happened? What if this happened? That's not what happened. The fact of the matter was he was speeding. She should have seen this. She should not have turned left. That's what the evidence showed. So is the jury's verdict consistent with logic? I don't think so. Was Mr. Random negligent? Perhaps. The jury, in our opinion, the jury found him to be 100% at fault.
Where does that verdict appear?
Well, in Special Verdict Form A, it says, was the defendant negligent? No, was the answer from the jury. No. So if the defendant was not negligent, to me, there's only one conclusion to be drawn, and that is that Mr. Random was 100% at fault.
In other words, there's no specific verdict form that says plaintiff is 100% negligent.
No, it doesn't. There's no verdict form that says that, because if the jury answers or signs verdict form A, they never get to verdict form B, which then allocates negligence. So if she's free from fault, then he must have been 100% at fault. I don't know how else I can interpret that finding by the jury. And it just doesn't make sense under what happened and all the testimony that Mr. Random was 100% at fault.
Was there an objection to the verdict forms that were submitted to the jury?
No, they're the standard CGI instructions.
And they were instructed that if you find the defendant not guilty, then you don't have to get to whether plaintiff was guilty.
Well, the verdict form says if you find the defendant was not negligent,
That's what I meant, I'm sorry.
then you don't go to verdict form B.
Exactly, so
So if there's no negligence on her behalf, then all the negligence must be attributable to Mr. Random.
or there's no finding of any, whether plaintiff is negligent.
No, there's no finding as far as the jury verdict forms are concerned. That's correct. Can I reserve the rest of this for
Yes, you
later, or
have,
do you have more questions before?
no, you're welcome to reserve the remaining of time. You have 3 minutes and 50 seconds. Thank you, counsel.
Good afternoon, Justices. I am Matt Holmes, and I represent the defendant slash appellee Elizabeth Baghdadi. Thank you for having us. We're here to talk about an accident, as you know, and I'm going to address 4 points that were raised on appeal. 3 have to do with the marijuana issue, specifically the perceived error that there was improper cross-examination of plaintiff concerning the effect of THC on his driving, the admission of the results of a urine tox screen from St. Anthony Hospital, the argument that the assumption of risk jury instruction was improper, and then finally, the argument that the verdict is against the weight of the evidence. And since the bulk of what has been discussed so far has been the assumption of risk and weight of the evidence, I'll start there. And in following up on the issue raised by Justice Martinez, the jury never got to the issue of plaintiff's fault, plain and simple. There were 2 special verdict forms, A, B. A asked the jury 3 questions. Was plaintiff hurt? 2, was defendant negligent? 3, was the defendant's negligence a cause of the accident? They answered 1 to yes, they answered no to 2, and they signed special verdict form A, determining that the defendant was not negligent. So there was no consideration at all of plaintiff's conduct based on the verdict forms. There was no objection at all to the form, content, and order of the jury instructions that were given in this case. Counsel has argued that, well, what that must mean is that the jury determined that the plaintiff was 100% at fault. And I would say, well, you know what that means? It means you didn't meet your burden of proof. Your burden of proof is to prove by preponderance of the evidence that the defendant was negligent, and they didn't do that. And that's, in my view, what the interpretation of that verdict should be. Nothing more, nothing less. So issues relative to the cross of Mr. Ranum about the effects of THC on his driving, the evidence about the urine tox screen, and the assumption of risk, all of that stuff, which all bears on whether Mr. Ranum was at fault, the plaintiff here, really you don't even need to get there. And to the extent that there was error, I would submit that it's harmless in this case.
Is it clear that assumption of risk has bearing only on the defendant's, the plaintiff's conduct, and has no bearing on whether the defendant was negligent?
The instruction doesn't specifically reference either party, Justice. It's part of a 2-paragraph jury instruction defining what negligence is. And the first paragraph talks about the failure to exercise reasonable care under the same or similar circumstances. The second paragraph says that assumption of risk may also constitute a person's knowledge of a risk and assuming it. The law says that assumption of risk requires knowledge of a danger and the consent to it. So they're basically two different definitions of what constitutes negligence, arguably either of which could be used by either party to the extent that there was arguments of fault against plaintiff and the defendant. The plaintiff argued against the inclusion of the paragraph on assumption of risk, so he did not make any arguments that the defendant in this case assumed any risk. Relative to the propriety of giving that jury instruction, a party is entitled to a jury instruction if it's supported by sufficient, competent evidence and it's consistent with existing law. It does not require the proponent to prove the evidence is conclusively accurate relative to that. And that's in the Vitito case. And in this case, as I said, that instruction requires knowledge of danger and consent to it. The evidence in the case was that Mr. Ranum admitted that he knew consuming 10 to 25 milligrams of THC affected him 2 to 3 hours later, and he knew that those effects did not allow him to safely operate a motor vehicle. And the evidence in this case was that Mr. Ranum admitted to Officer Bankston at the Parker Police Department after this accident that, and let me preface this by saying, Mr. Ranum's first words to Officer Bankston that night were, "Am I going to jail?" Officer Bankston then asked him, "Why would you ask me that?" And Mr. Ranum's response was, "Well, because I consumed 20 milligrams of THC 2 hours before the accident." The risk assumed by Mr. Ranum in this case was getting behind the wheel of a car knowing it was not safe to do so. And on top of that, both Officer Faulkner from the Parker Police Department, who did the investigation, and Mr. Ranum admitted that his conduct that night was reckless. And as we know, what reckless means is that someone is operating a motor vehicle with wanton or willful disregard for safety. There are a couple cases that...
Mr. Holmes, I have a question.
Yes, sir.
Was there any evidence in this case that the THC affects the ability to drive, other than his admission that it affected his ability to drive?
Yes, Justice Martinez. The defense called a toxicologist who was accepted as an expert witness in that field, Dr. Sederick. And he testified about the effects of THC on a person's ability to operate a motor vehicle. And those effects include difficulties with perception, difficulties with judgment, difficulties with reaction, numerous things.
So that was basically your, for lack of a better word at the moment, sort of traditional testimony from an expert regarding effects. Obviously, the plaintiff's own testimony would not be that of an expert. How do you analyze that testimony about the effect of THC?
I think Dr. Sederick, in addition to the admission of Mr. Ranum's own testimony, also talked about amounts, 20 milligrams. He talked about absorption rates, and he talked about the timing that someone is going to experience those adverse side effects and how that's going to affect a person's ability to operate a motor vehicle. So I think it's a combination of those two things, Justice Martinez. There are a couple of cases on this whole assumption of risk. Carter, Vitito, and Wark, which are all cited in the briefs. And I would point out the distinction in those. In Carter, where they found it was improper to give the assumption of risk, the driver in that car was in a proper passing lane at the time of the accident, and someone turned and left in front of him. And they said, well, you can't assume somebody's going to do that. In other words, the person who was passing wasn't doing anything wrong. The other two cases, Vitito and Wark, are distinguishable, and then in both of those cases, the plaintiffs were in the process of doing something either illegal or inappropriate or beyond the standard of reasonable care. Specifically, in Vitito, a motorcyclist was making a U-turn and accelerated into a vehicle that he thought was moving when it was stopped or moving very slowly. And in Wark, the issue there was that the plaintiffs got in a vehicle with a person that they knew had been drinking alcohol. So that's how I would distinguish that from our case. And that's what we have here. We have a person who gets in a car knowing he consumed marijuana and knowing the effects. Let me talk about the weight of the evidence. Negligence and causation, as we know, are fact questions for a jury, and they're not to be overturned where there's competent evidence from which the jury could have logically reached its verdict. The happening of an accident raises no presumption of negligence on either party. And we know that the burden of proof to prove negligence starts with Mr. Ranum. And the jury simply determined that Mrs. Baghdadi was not negligent. We don't know what they would have decided relative to the fault of Mr. Ranum because they never got over that initial threshold. Mr. Ranum's fault could have been 1%, it could have been 99%, but we never got there. What they are essentially arguing, justices, is they want there essentially to be strict liability when you make a left turn. I mean, there's not even a presumption of negligence in the law when a person makes a left turn. And they're also ignoring the fact that there are two aspects to proximate cause. There is causation in fact, which is the but-for part of it, and there is legal causation, okay? So maybe the accident doesn't happen if she turns left, but what about the other part of the analysis, okay? And that's where they had the real problem at trial. Officer Faulkner testified, and he admitted that he did not analyze speed. He did not rule out speed as the proximate cause of this accident because he did not do a time and distance analysis. In other words, we have the black box data from both of these vehicles that tell us exactly how fast they were going, 5 seconds all the way up to the point of impact. okay? So he didn't make any determination as to where she was and where he was as she's pulling up to that intersection. And what the defendant's expert said is that while she's pulling up to that intersection to turn left and she's 29 miles an hour and she's slowing, and roughly 5 seconds before the impact, he's 500 feet away, okay? So she's making the judgment, does this vehicle out in the distance, way off, seem like it's far enough out that I can safely make my left turn? Now, the standard here is reasonable conduct, okay? So he's 500 feet away. She gets to the point where she makes the decision, she perceives, she reacts, she judges that it's safe to make my turn. Our expert testified that as she's making the turn, he was still between 200 and 300 feet away. And then, boom. When you're averaging 70 miles an hour and you're going 100 feet per second at night in a 40 mile per hour speed limit zone in the entrance to a residential neighborhood, what our expert said is that she was reasonable in judging that he was far enough away to make her left turn, that she was reasonable in assuming that he would not be traveling 30 miles an hour over the speed limit. And in fact, there's a jury instruction that said that she had the right to assume that he would obey the law. The question for the left turn statute is whether the person is within the intersection or so close as to constitute an immediate hazard. And that's what our expert analyzed. Where was Mr. Ranum when she is at the point of making that judgment decision about whether it's safe to make her left-hand turn? And he said that she was. Faulkner didn't do that analysis. Our expert determined that had Mr. Ranum been driving the speed limit, there would not have been an accident at all. And in fact, had he been driving the speed limit and he reacted at the same point he reacted that night, he wouldn't even have gotten to the intersection. There would have been no accident at all. The presence of the conflicting evidence raised in the appellant's brief is insufficient as a matter of law to overturn the jury's verdict. As long as there's competent evidence, there is competent evidence in the form of our expert witness. And then I'll just wrap up real quick on the THC tox screen. The tox screen report did not come into evidence. The only thing that came into evidence is the fact that it was positive for THC. That's it. And our expert, Dr. Sederuk, said as much. I reviewed it, I relied on it in part to making my conclusions, and it was positive. That's it. The report didn't come in. So there's no error in that sense because all it merely did is confirm what 4 different witnesses said. The paramedic, the police officer, 1 doctor at Parker, and 1 doctor at St. Anthony's. So there's no error, we don't think. And my time is up, so thank you.
Thank you, counsel. Rebuttal?
Briefly.
The toxicology report from St. Anthony's Hospital specifically says that it's not to be used for non-medical purposes. It says right on the form.
Is that binding on the court, and if so, why?
I think it's binding on the court because the doctors are saying you can't use this for any purposes outside of medical treatment.
Do you have any authority that supports that?
No, I don't. I just think that when you get a report that says you can't use this by the doctors, that you shouldn't be able to use it. And the trial court allowed them to use that. The main theme throughout defense's approach to this trial was, Mr. Ranum, you're under the influence of marijuana, and as a result of that, that caused the accident. When that's just simply not the case. There's no evidence that he was under the influence of marijuana at the time of the accident. The only thing we've got that shows that he had any marijuana in his system is the St. Anthony's toxicology report, which specifically says not to be used for non-medical purposes. So I think the trial court erred in allowing that testimony to come in. The report itself did not come in, but the testimony did. The toxicologist, Dr. Sertak? Cedric? He testified marijuana reacts differently with different people. So how it reacted specifically with Mr. Random, he didn't know. But as just a general statement, that could affect his driving. Although Officer Bankston at the hospital did a DUI check on Mr. Random, he found his perception was fine, his reactions were fine, and they had no evidence that he was under the influence of marijuana at the time of the accident. So we did have that check at the hospital. The one thing, this isn't a residential neighborhood. You got a 4-lane street, 40 miles an hour. Most residential streets that I know of are 25. So it's not really residential. Officer Faulkner testified that he didn't do a speed analysis, speed time distance analysis. But he testified that, and I think his testimony was, you know, you can have two cars going 100 miles an hour at each other, and then, while that's not something he liked, it happens. But there's no accident until somebody turns left in front of the other person. So the evidence was clear that there was fault on Miss Baghdadi's part here, and how the jury finds that she was not at all negligent in this, this defies logic. The jury had to consider the speed, the marijuana, everything that he did, Mr. Random, but did not conclude or did not use her failure to yield in making their decision. Thank you very much for your time.
Thank you to both counsel for your arguments and your briefing. They will help us to make our decision in this case. Your case will now stand submitted, and a written opinion will issue in due course. That concludes our afternoon docket. This court will stand in recess, and the bailiff may so announce.